Hello, and thank you all for attending week 3 of BFSG's 4-week summer webinar series, today covering estate and legacy planning. A few housekeeping items before I pass it over to our panelists today. There's a Q&A box in the Zoom menu on your screen for all of you on a computer, which is distinct from the chat box. Please type all questions into the Q&A box, and we will either type a response back to you or address them all at the end of an approximately 30-minute presentation during a live Q&A for all attendees. For compliance purposes, on a live and recorded webinar, we will not be unmuting lines today. Please type all of your questions into the Q&A box. Should your questions be more personal in nature, at the end of the webinar, we will provide contact information for all panelists and encourage you to reach out directly rather than asking personal questions on a live and recorded webinar. The same registration link will also be active about 30 minutes following the webinar for a full on-demand replay as well, in case you would like to re-listen and share with any friends and colleagues. Lastly, this series is a result of numerous surveys where we saw these topics come up time and time again. So please fill out the 1 to 2 minute post-webinar survey to provide feedback on your thoughts and let us know any other topics you might like to see from us in the future. With that in mind, let me pass it over to our panelists for introductions. Keith.
Great, thanks, Chad. Well, first of all, I would like to thank everyone for attending today's webcast on estate planning. My name is Keith Johnson. I am a senior education specialist and financial planner with Benefit Financial Services Group. I'm joined by Paul Horn and Mark Blom, both who are senior financial planners with Benefit Financial Services. We also have a special guest today, Jeff DeFrancisco. He is an estate planning attorney and founder of Presidio LLP. Jeff, why don't you take a moment to introduce yourself?
Right, good morning, everyone. Thank you for having me. As Keith said, I am the founding partner of Presidio LLP in Pasadena. We specialize in estate and tax planning, mainly for large estates. So we do a lot of irrevocable trust planning and estate gift tax returns, and as well as basic planning.
Excellent. Thank you, Jeff. So now I will actually turn it back over to Chad. He's going to kick off today's presentation with an interactive poll. Chad?
Great. Thanks, Keith. Hey guys, so we have, I think, 2 polls today. One we're going to kick off right now. We'll have another one in a few slides. This is interactive. In just a couple moments, I will launch the poll and something will pop up on your screen. The first one is multiple choice. Just to try to gauge the audience today, what level of documentation do you already have in place? Please select all that apply. I'm going to launch polling right now. I'll leave it up for about 20 seconds while we gather responses from the group. Great. So with that, let me end polling real quick. And I will share the results with the group. We can see, about over 70% do have beneficiary designations in place. That is great to see. That's one place that a lot of people definitely don't have up to pace. And for some people at the very bottom, we do have this is all another language. Hopefully you find this content today with Keith and Jeff really useful in kind of addressing some of those things and helping you as you prepare for the future. Keith, let me pass it back to you.
Great. Thanks, Chad. Okay, so if you die without a will, you're said to have died intestate. So that essentially means your estate will go through probate. And what can happen when an estate gets caught up in probate? So if we back up here, let's take a second to look back to the year 1977. Elvis Presley died that year. His estate was worth more than $10 million. Unfortunately, it did go through probate. And then after taxes, fees, his family was left with less than $3 million. So in looking at this recent map, it seems like not a lot has changed. More than 50% of Americans with children actually die without a will. So when we talk about estate planning, if you have no money, no assets, no family, no children, do you necessarily need an estate plan? Maybe not. For everyone else, you should have a plan designed to avoid probate, protect and control your assets, your healthcare decisions, protect from minor children, and then also pass the maximum amount of your estate to your heirs or beneficiaries. So at this point, I'll actually turn it back over to Jeff. He's going to talk a little bit about probate.
Yeah, so what happens if you die without an estate plan? So you go through what's called the probate process. You see on your screen here a definition, an action or process proving before a competent judicial authority that a document offered for official recognition and registration as the last will and testament of the deceased person. So what is this really saying? So probate is really a court process of transferring assets from the decedent to the decedent's beneficiaries. And the decedent's beneficiaries, if you don't have a will or any document, as Keith said, you go through what's called intestate succession, which is the probate code. The California law tells you who your beneficiaries are and who's going to get what. So most people don't want that, right? So you use at least a will in order to direct who your beneficiaries should be. If you go to the next slide, though, you'll see probate is something that in general we try to avoid. You say, well, why would we want to avoid it? This sounds, like a good process for transferring assets. Well, there's kind of three main reasons why we avoid it. So one is time. It takes a very long time to get through the probate process in California. Other states are a lot quicker. California is not. That was pre-COVID. In this COVID world that we're in, the time has even gotten longer than what it has. And so how long does it take? Pre-COVID, a very simple estate with no complications would usually take a minimum of 9 months, more likely 12 to 14 months. Post-COVID, some of this is pushing 2 years now. You just can't get the hearings, you can't get into the courts. It just takes a very long time. The other part is cost. Probate is done on a statutory fee schedule. So the code says this is how much you get as the attorney, and this is how much you get as the executor in order to probate an estate. So an executor is the person who's named in your will, or an administrator if you don't have a will, who's the person who actually goes to court and says, court, so-and-so died, I need to pass these assets on, let's go through the process. So you see on the chart here that it's a percentage. It's 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, and then it goes up. So you see on the chart, for even a very modest estate of $500,000, you're going to spend $13,000 in attorney fees. You'll also spend another $13,000 for your executor. So it's $26,000 just to get into the court process. And then you have all your filing fees, which will be a few $1,000s by the time you're done. You have to publish in a newspaper. There's a lot of steps.
So you're essentially giving up 100% control to the state to make every decision.
Right. And the third part is publicity. Probate is a court process. It's public. Every document you file with the court can be accessed by anybody. So all of your financial information, all of your beneficiaries, all of your addresses, everything gets published. And if anybody wanted to find it, they could. So what do we do to try to avoid probate? What are the documents that are involved with our estate plan? So the general estate plan, at a very simple level, would be what 71% of you said you already did, which was beneficiary designations. Right, and so this could be on insurance policies, it could be on your retirement policies, it could be on a bank account, right? But just making sure there's some beneficiary, that's one way of avoiding probate. The other way, and probably the most common way, at least here in California, especially if you own a home, you're going to want to look at this. If you have any type of substantial assets, you're going to want to look at this, which is having a living trust. Or sometimes it's called a revocable trust. Some people call it a family trust. All the same thing. A lot of people just have different names for the same type of trust. And a trust at a very basic level is just an agreement between you and a trustee, who initially is yourself. And then when you die, you will name who you want to be the trustee, to manage your assets and to distribute your assets when you die. And again, it's one of the most common probate avoiding techniques that we have out there. The other documents involved are a will. So we said that a will goes through probate, which is true, but you still want to have one just in case. So in case, let's say, the most common example is oftentimes you create a trust, you put your house into the trust, so you retitle your house, and then a few years later you get a mortgage and your mortgage company refinances for you. A lot of mortgage companies will take your house out of your trust, and they don't always put it back in. So it's one thing you always have to check. So let's say they don't put it back in and you die. Well, great, you have a trust, but it's not going to do anything if you can't get the asset into the trust. So the pour over will is what we use. So basically, it's a very simple will that says, if I die with an asset not in trust, go through the probate process and pour the asset into the trust, which is why we call it a pour over will. So it's a very abbreviated will. The other two main documents in a basic estate plan would be powers of attorney. So durable power of attorney. is for assets, financial matters. So these kick in if you're alive, but you're incapacitated. So you cannot make a financial decision for yourself. Doesn't really have anything to do with probate because this is dealing with while you're alive, which is part of the overall package. And then the other is advanced healthcare directives. We used to, and some states still do have them as two separate documents, powers of attorney and living wills. California now puts them into one document called the Advanced Healthcare Directive, which the two components are: one, naming who your person is that you want to make medical decisions for you if you're not able to. And the second part of that is, what are the medical decisions that you want them to make? You know, do you want to pull the plug? Do you want you know, what type of home care versus, you know, assistance in a facility? So if we're looking at probate then, going on to the next slide, and at the probate property. So what assets go into probate? So at a very simple level, we can say any asset that's in your individual name is going to go through the probate process, unless you have one of these non-probate properties. So some examples of non-probate: joint tenancy property. So this is property that you own with another person, but it actually has to be titled joint tenancy with right of survivorship, or joint tenancy. And what that means is that when one person dies, the property automatically, by operation of law, goes to the other person named on the account. And don't confuse that with what's called tenancy in common. So this would be, you know, me and Mike have an account together and it just is in my name and Mike's name. In that case, if I die, it doesn't automatically go to Mike. My asset is going to pass according to my will or my estate plan on, you know, whatever I have. So it has to say joint tenancy. Other examples are anything, again, that passes by beneficiary designation. So life insurance. You have to be careful with life insurance, as I'm sure, you know, Keith, you can chime in here on, you know, a little later on, I think you'll actually talk a bit about, you know, designated beneficiaries and making sure that it's not just the estate, you know, that winds up being the beneficiary on those policies. Retirement accounts are the same thing. Making sure that you're naming individuals or naming a trust, although there are some tax consequences with naming a trust. So you'd want to talk through that with your tax advisor. But you don't want to just leave it to the default or not have one. And be very careful, especially with spouses. So oftentimes people say, well, great, I've got a beneficiary, it's my spouse. Great. But if you both die in a common car accident, let's say, and there's no contingent beneficiary on either one of your retirement accounts, those assets are going to wind up in the estate and you're going to wind up probating. So you want to make sure there's always a contingent beneficiary named on there that's qualified to avoid probate. Payable on death designations. So this is just beneficiary designations essentially on a bank account. Go to your local bank, you open up an account, you can put a beneficiary right on there so that if you die, the beneficiary gets that account. Different than joint tenancy, right? They don't have any access to it while you're alive. They just get access to it after you pass. And then lastly, as we've talked about, is property and trust, right? Which is, again, the most common vehicle. So let's talk about the living trust a little bit. Some of the benefits. If you die and you don't have any documents in place, I'm sorry, if you become incapacitated and don't have any documents in place, you have a real problem, right? Who comes in and starts managing all of your financial affairs? You know, who's paying the gardener? Who's paying your bills? Who's making sure, you know, your medical bills are taken care of? And a durable power of attorney helps, but the trust is also one of the vehicles that we use to name a successor trustee. Again, a trustee is just a person that you put in place to help manage your affairs. If you don't have that in place, what normally winds up happening is somebody goes to court and has to get what's called a conservatorship. And a conservator gets put in place by court order to manage your affairs for you. And so very expensive, again, very public, takes a long time. And again, you want to avoid that by trying to use a living trust. Trust also provide a lot of privacy. We talked about the court process being, you know, public. Well, the trust never gets filed with the court. So nobody sees that trust document other than your beneficiaries. So within your family, you know, of beneficiaries, they might know what's going on after you die. While you're alive, they don't see that. Only you see it, you and your trustee. And again, while you're alive, you're your own trustee. So it's really just you who knows what's happening, which is a huge benefit.
Okay. Jeff, just a quick question here. So if you're someone, you own out-of-state property, maybe it's a rental or a vacation home, would you recommend having that property titled in a trust to maybe minimize some of that ancillary probate, out-of-state probate?
Yeah, it's a very good point. So absolutely. Again, each state's going to have its own laws. If you already have a living trust, I would definitely suggest putting your out-of-state property into your living trust. This way it's all managed in one spot. If you don't do that, then you wind up having a probate in the state where the property is located. And you may have a probate in California as well. So you may actually wind up having two probates, if you don't have a trust in place in there. So what we really try to do is minimize confusion and maximize the consolidation of assets. So putting them all into one vehicle is usually the preferred method.
Perfect. Thank you.
All right, so here's just some quick examples of how a trust could be helpful in a multiple marriage situation. So let's say you have kids from your first marriage and wife dies. So you assume, well, my husband's going to take care of those kids, right? I don't need to do anything about it. I'm okay. Well, statistically, husbands almost always remarry. Right? Especially the older you get, we see it more and more again that the husband will remarry. They're used to having a spouse around, and there's something in human nature. So husband remarries and has kids with new spouse, or maybe the new spouse already had kids of her own, and says, well, gee, this is my family too. I'm going to leave some of my assets to new spouse. I'm going to leave some of my assets to the new heirs. And if you don't have a trust, and you just have a kind of leave it to the probate code, or have a very simple will that says everything to my spouse, right? The kids from the first marriage could wind up with nothing. And so a good way of avoiding that is by using a trust where you can plan for it. And you can say, well, husband, when or in this case, if wife or husband, whoever, dies first, you leave assets in trust for the spouse. So let's say my wife dies first. She puts her half of the estate, so her separate property and her half of the community property goes into a trust. And it says, well, Jeff, you can use the income for your life. And if you need the principal, you can use it. But whatever's left over after you die, that's going to our kids. So it doesn't allow the spouse to redirect the assets to a new spouse or to new kids. So when you kind of compare the difference between the will and the trust, and there's a lot of advantages to a trust over a will, right? Avoiding probate, again, a huge advantage, time and money. Providing for your minor children. Trust, you can set forth the terms for how you want your kids to get it. If you want them at 18 to receive all their assets, with a very simple will, if you just name your kids at 18, they're getting everything. Most people say, well, gee, that's too much money. I want it at 20 or 25 or 30, or only want income for certain purposes or what have you. And so the trust is a real good way to be able to do that. Another is disability planning. If you have somebody in your family who is on public benefits and needs that support, a will certainly disqualify them if you're leaving them assets outright. But you can use trusts in a way in order to ensure that they continue to receive their benefits. We talked about the blended families, second marriages. In general, just trusts are just easier to deal with, right? You don't have to go through court. You can just do everything within your family with your trustee. And you can get as sophisticated as you need to, within the trust, depending upon your estate. There's a lot of taxes to be paid or hard to value assets. If asset protection is something that you're after, trusts are the way to go. Administrative expenses, in general, trusts tend to be cheaper. It's not always the case. It can be that the probate sometimes is cheaper than the trust administration, but in general, using the trust would be the cheaper way of going. Initial costs, certainly cheaper with the will if you're just using a nice, simple will there. And for simple estates, a will makes a lot of sense. There's a exemption for $166,250 is the California, what we call small estate exemption. So if your estate is under that amount, you don't even have to go through the probate process. You can do what's called a small estate affidavit. But if you're over that amount, which if anybody owns a house in California, you're probably over that amount, right? Then you're looking at the revocable trust.
Great.
So Keith, you want to talk a little bit about the beneficiary designations?
Thank you, Jeff. And actually, at this point, Chad, do we have our second poll here for the group?
Yeah, we do. And so I think it's very timely, especially with over 70 people saying they already have a beneficiary on file. So for those of you that don't, and then for all of you that do have your beneficiaries on file, it's also important to update those from time to time. So when was the last time you reviewed your beneficiary designations? I'm going to launch polling now. Again, I'll leave it up for about 20 seconds just to gauge the audience and see how often people are doing this. Great, and with that, let me close polling and I will share results again. And we have a ton of people that are reviewing within the last 1 to 2 years. So definitely really good from our participants on this call. Let me stop sharing results and I'll pass it back to our panelists.
That's great.
That's great. Yes, absolutely. So yeah, Jeff talked a little bit about this earlier in regards to beneficiaries, and I can't emphasize enough the importance of ensuring they're up to date. And it sounds like with quite a few of you, they are up to date. By not naming a beneficiary or naming your estate, as Jeff talked about earlier, as a beneficiary, that can create a taxable event for your beneficiaries or your heirs. When you name a minor as a beneficiary, it's important to realize that because they're not age of majority, control of those assets, that will be granted to the minor's guardian. So there are some important considerations there as well. And again, keeping those beneficiaries up to date, I can't emphasize that enough. I can't tell you how many times I've heard stories firsthand. People get divorced, they remarry, and not updating their beneficiary on a 401k plan. Then they die. So if the ex-spouse is still listed as the beneficiary, well, guess where that money goes? To the ex. And that trumps anything, and Jeff, correct me if I'm wrong, anything stated in a will, trust, or anything else, right? As far as hierarchy?
Correct.
Perfect. Okay, I'll turn it back over to Jeff.
All right, so we've been talking about kind of basic estate plans, the documents that every person should have, their estate plan. Some people also are going to need to have some additional planning related to estate taxes. So currently, we have an estate tax exemption of $11.58 million per person. So this means that if you die and your estate is 11.5 or under, you will not have an estate tax. But we have to be really careful with these numbers because they change all the time. Historically, and this number sat at 675,000 was the exemption for years and years until 2001, where we started having some changes in the law, and then it became $1 million, and then it got to 3.5, and then 5. 2010, we had this anomaly in the law where there was no estate tax. Then it came back, right? And again, it's been creeping up and creeping up. So the current law says on January 1st, 2026, that exemption is going to drop to $5 million with some inflationary number. Although there's also a belief that if the Democrats take control of the House or Senate or presidency, that there'll be a push to lower that number sooner. So you'll hear a lot of people in tax planning say, it's a use it or lose it situation. So if you're in a situation where you could use $11 million, they say use it now because you might not be able to if the exemption drops back down to $5 million. So it's always a moving ball with the taxes because you never know what it's going to be or when it's going to change. So you kind of want to keep your eye on that. And it affects your basic plan because there are patterns in your basic plan that are set up that are related to estate taxes. So when your estate planner tells you, every 3 to 5 years, you should at least, give a call, take a look at this plan, that's partly why. Your estate changes, the law changes, you want to make sure you're staying up to date on what's happening. You can't just do a one and done and assume it's all going to be okay because the laws are changing around it. On the state level, very few states at this point have state estate taxes. And we have a chart on the next slide that'll show you which ones. And this is because a lot of states, actually California technically has an estate tax. It's just that the rate is 0. And what happened is when there was a change in the law in 2001 at the federal level dealing with credits, it basically wiped out all of the estate taxes at the state level because of the way that the laws were written. So unless the legislatures of the states change their laws, you have a lot of states with no tax. The ones that you see on your screen here that have tax have either changed their laws or had them set up before, where they have an estate tax, which is a tax that the decedent's estate dies, or an inheritance tax, which is a tax that the recipient pays. And sometimes you can have both, right? So you got to be a little bit careful on terminology. In general, we just kind of say estate and inheritance tax. If the federal law changes again, there is a possibility that some of those states that don't currently have a tax will automatically, because of their statutes, have a tax again. So this is another reason, just kind of you have to keep your eye on the different exemptions. Some of the states' exemptions tie to the federal exemption. Others have their own exemption. So it becomes very complicated if you have assets or live in one of these states where you have a state estate tax as well as a federal estate tax.
Thanks, Jeff. I think so. So the bottom line here, I mean, estate planning is definitely not a do-it-yourself project. So it's really important to reach out to a qualified attorney to ensure that your plan doesn't contain any legal blind spots, so to speak, that maybe you've not considered. The most popular estate plan is obviously doing nothing. You can do it yourself, but some important considerations include not overlooking beneficiary designations, retitling of assets. Jeff talked about the mortgage companies when you own your home. You can definitely disinherit folks that you did not want to. So getting help with all of this is definitely recommended from a legal perspective. So some additional steps to consider here. You want to find a qualified team to guide you on this journey, so to speak. Gather your important documents together, review that data, your team suggestions and recommendations, and then create and implement a plan to ensure things stay up to date and on track, and definitely do those reviews. So at this point, I would like to thank everyone for listening. We will be wrapping up our summer series next Tuesday at 10 a.m. and Paul Horn and I will be discussing the 7 pillars of financial planning. This presentation essentially puts everything together that we've been talking about, from determining how much retirement might cost, to expense debt management, to tax planning, risk management, and we do have the link to register. It's at bfsg.com/bfsg-university. Also, how can we help here? If you're interested in a complimentary review of your beneficiaries, or if you'd like to develop a strategy for leaving a lasting legacy, please contact Jeff or myself. If you're someone you feel pretty good about how you're currently managing your estate plan, but you want to validate what you have going on, you can request a free estate planning checklist by either emailing myself or contacting us via the toll-free number at 888-726-9378. So last but not least here, this is our team of experienced financial planners. We're here to help during these uncertain times. All of our planners hold the Certified Financial Planner designation and act in a fiduciary capacity. So what does that mean? That means we always put our clients' interests first by law. We don't sell any insurance or financial products. Also, in addition, every planner on this screen has at least 10 years of experience and focuses on a variety of different areas to ensure we're taking care of the unique challenges of our clients. So with that being said, I will turn it back over to our moderator, Chad, and he will take it from here.
Great, thank you, Keith and Jeff. A couple of housekeeping items. I did just post, for anybody that does need to drop, I know we did say about a 30-minute presentation. I did post in the chat box a link to both a survey. There's a QR code on the screen as well, if you'd like to do the survey, as well as a link to download the slide deck from today. We will have one email blast coming to all attendees tomorrow that will include a link to the registration for next week's webinar, as well as a link to the slide deck as well, in case you are unable to access it in the chat box today. So for all of you dialing in today. Again, before we start the Q&A portion, at the very bottom of your screen, there is a Q&A box. We have a good amount of questions right now already, but please feel free to continue typing your questions in. If we are unable to address all questions by the top of the hour, please feel free to reach out. Keith did provide our contact information, financialplanning@bfsg.com. The email tomorrow will also have Jeff's email address if you want to ask him questions directly as well, such that you can reach out and touch base directly with him. And so as we begin, our first question. Number 1, can a trust own an IRA account?
General answer I'm going to say is no. There is an exception to that, but so in general, the participant owns the account. You can name a trust as a beneficiary of the account. After the participant dies, then the trust owns the account. So it's a bit complicated in there. There is a little caveat of something called a trustee IRA, which you can put into a trust, but it's not a very typical product that is used. So most of the time I would say it should be in your individual name. If you want to name the trust as the beneficiary, talk to your tax advisor. There's some or financial planner. There's some very significant consequences to naming it improperly. And we just had a change in the law at the beginning of the year, actually, that just changed the way beneficiary designations work with IRAs.
Great, thank you. Next question is, if I have a power of attorney through PERS retirement, do I need to also designate another mechanism?
So I'm assuming what this is a power of attorney for your retirement account itself. And if that's the case, then yes, because you still need a power of attorney for non-retirement accounts. Right? Powers of attorney can be as broad or as limited as you need them to be. So you need to check the language to make sure that it's a broad power and not limited to just that one account.
Yep. Next question, I think should be quick, is what does POD stand for?
POD means payable on death.
So the next is, I have a living trust. It was created a little over a decade ago when my kids were minors. Now that they're adults and I would like to make changes, any advice on how to proceed?
Yeah, so I think there's a couple ways here. One would be to talk through with your financial advisor and really go through your current plan, get some ideas for some changes, and then at some point you'll need to bring an attorney in the mix, or you could talk to the attorney directly, and again make the changes to the trust. So it's really finding a qualified estate planning attorney in your area. Your financial advisor could help you with that as well.
So next question is, does the beneficiary of a POD bank account pay taxes on that when it gets passed on to them?
So there's no income taxes that get paid when it passes. There could be an estate tax if the value of the decedent's estate is over the exemption amount, then a portion of that account would be subject to taxes.
And then, so one question is, we have a ton of people from California on the call today. There's also a bunch of people from Arizona, Boston, Florida, Texas, et cetera. Is there any big considerations that people living outside of California should be considering that might be different from those in the state?
Yeah, so it depends, I suppose, if it's domestic or overseas. All right, so if we're talking overseas property, that brings a whole level of complexity for what we call inbound trusts and outbound trusts. The tax laws are different. So you definitely would want to talk to an international estate tax planner if you're dealing with a lot of out-of-country assets. If you're within the United States, like was mentioned in the presentation, a vacation home, what have you, you might keep in your domestic, the trust of where you reside. Yes.
Next question is, for retirement accounts with multiple beneficiaries, if one of the beneficiaries passes away before you, does their share automatically go on to the other beneficiaries?
Keith, you want to take that, or?
Yeah, sure. So it depends on how you have the beneficiary set up. So if you have your primary beneficiary set up, they predecease you, then the contingent beneficiaries would receive the assets, generally speaking, on a pro rata basis. But you can actually set that up, that maybe it's 4 contingent beneficiaries at 25% per beneficiary. If something were to happen to one of those beneficiaries, then you would go in, and it's as simple as filling out a beneficiary form, and it takes no time to do. And you can structure that. That's what's nice about a beneficiary, is you control it and you can change it at any time. So there's no automatic process necessarily, but to go in and update things. That's why we talk quite a bit about keeping things up to date as far as beneficiaries.
Great, and so, from the order, I'm going to skip a couple of questions because I think it's relevant and it ties really directly to this one. Can you guys please define, Keith, primary, secondary, and contingent beneficiaries? For example, if I have 2 children designated as my primary beneficiaries 50-50, do I need to designate a secondary and contingent beneficiary?
I would always have a secondary or a contingent beneficiary. It's that extra layer of protection. So if you have the kids on 50-50, whether you, and maybe Jeff, you can chime in here, as far as a trust, yeah, there are a lot of issues listing a trust as a primary beneficiary. Might this work as a contingent though, Jeff, as a safe haven to not get caught up in probate?
Absolutely. Right. We always say, don't let the tax tail wag the planning dog. If it makes sense, to avoid probate or it makes sense for your family, you do it, even if it's not the most tax efficient way of handling it.
Great. And the next question is, how does a living trust work in the case of incapacity? I thought it was only used as an after-death vehicle.
No, so trust is used for during life and after death. So there's provisions in your living trust that will say, if I become incapacitated, then here's who becomes trustee, so who takes over your financial assets. And then there's provisions in there for making sure that, that trustee provides for your health care, provides for your needs, and pays for you. So it's used for both during life and after death.
So this next question might be more of an it depends type of answer, but what is the general difference between a simple estate and a more complicated one?
Yeah, it depends is a good answer. So simple estates, tend to be ones where it's, maybe it's a house and just some cash accounts, some security accounts. There's no intellectual property, no oil, no business interests, no LLCs, no entities, and everything is, say, passing, to the kids. And then you kind of look at the other factors, right? Once you start dealing with tax issues, it gets complicated. Business interests. If you're leaving things to charity and nieces and nephews and kids, and there's different types of trusts and terms. So it really just kind of depends on your asset makeup and your beneficiary makeup.
And that's just to piggyback off that, Jeff. So if you're someone, you have a charitable inclination, you want to give to a charity. If you don't have an estate plan in place, like a will, from what I understand, you can't give to a non-family member. Is that correct, Jeff?
Yeah, that's correct.
Okay.
Great. So next question is, if I have a living trust, do I need to kind of each time I buy or sell a house, hire an attorney, to kind of put those homes in and out of a trust each time? And does that get expensive and complicated?
Yeah, you don't have to. Your escrow company should be able to do it. All you need to do is provide them with the title. So when you do your estate plan, your attorney should give you a document called the certification of trust that has an abbreviated version of the name of your trust and all the information that the escrow officer would need. And you can just buy it and sell it in the name of the trust directly, and then you don't need to have an attorney involved.
Yep, great. And so can you quickly discuss the difference between a revocable trust and an irrevocable trust, and when might be best to use?
So a revocable trust is one that can be changed. An irrevocable trust is one that once it's created and funded, you cannot change its terms. So the revocable trust is what we've been talking about mainly through this seminar. These are things where you can change it anytime you want to. It's kind of like your other pocket of money. An irrevocable trust is usually used for tax planning purposes or asset protection purposes. So if you're trying to save estate taxes or save some income tax or give to charity, you might use an irrevocable trust.
Thanks, Jeff. Next question is, if I do a 1031 tax deferred exchange and move my estate / assets to a different state, will my children still have to pay capital gains in California upon my death?
Yeah, so California just instituted a rule a few years ago where they now track the basis or the taxpayer needs to file it's a special form with the state of California every year while that property is in the other state, so that California can track that property. And when you sell that property in the other state, California is going to want a portion of their tax.
So we get for living in California.
That's it.
Next question is, so it sounds like we really can just use beneficiaries on bank accounts, IRAs, and 401ks, life insurance, and that might suffice in most cases. But if you own a house, car, or any other hard assets, you really need to have a living will. Is that correct?
It kind of comes down to ordering of deaths. So, you know, if your beneficiary died before you, you would still wind up in probate with that bank account, whereas if you had it in trust, you wouldn't. You also have to think about debts and taxes. So when you die, your last expenses need to get paid from somewhere. So if you have beneficiary designations on all of your accounts, then the question is who's the one who's responsible for paying those debts? And you could potentially put all of your beneficiaries at risk of being sued by the creditors, you know, to come after those funds. So on only a very, very simple estate, you know, like if you had no house and what have you, would I say use beneficiary designations? But even then, I would still say use a will, right? You still want to control, you know, where your assets are going in a controlled way, if you will, and to have somebody there who can manage it if you need it, so that your beneficiaries don't start fighting over who's paying the taxes, who's paying, you know, the debts and expenses.
So next question is, thinking about, what if the trust was poorly written? What recourse would family members have? The example here is, say you have 3 adult children, spouse deceased, trust is created with 1 kid as a trustee, executor, and sole beneficiary. Do the other 2 adult children have any recourse?
Well, so recourse on a trust really comes down to a lot of things of what we call the intent of the person who created the trust. So if that scenario is what father actually wanted to create and was of sound mind and not being unduly influenced, there's really not a whole lot that those other children can do. If those children can prove that, you know, he was influenced or didn't understand what he was doing, didn't have the capacity to make it, then those kids could bring a lawsuit to contest the document and try to make the court help make changes to it.
Yep. And so next question is, any advice on, how to find the best person to help with all this stuff? Be it financial planning, estate planning, CPAs, all that kind of stuff.
Keith, you want to take that?
Well, on the financial planning side, checking out the CFP website, the Certified Financial Planner website, and I think actually there is a letsmakeaplan.org website. What you're looking for, again, on the planning side is someone who's a fiduciary. So again, it's your best interests that come first by law. And then secondly, someone who charges a transparent fee, not someone who's trying to generate commissions or sell insurance products. So definitely look for someone. I would recommend a certified financial planner who is fee only or fee based.
And your financial planner will have a network of people that they could help, put you in touch with if you need to find a CPA or a attorney. Your CPA will also have a network of people that they probably work with. On the attorney side, you can look at your local bar associations, usually have a referral service that you can go to that website. And there's also a group called ACTEC, the American College of Trust and Estate Council, actec.org. If you go to their website, they will also give you names of estate planning attorneys in your area.
Yeah, and so I think that was all the very objective guidance, and start with your local areas and find somebody local to you. Keith, if you put the contact information slide back up, if you really don't have any of those resources, feel free to reach out to either of us, Keith or Jeff, and we can at least point you in the right direction, being that we do have all those resources to assist with as well. So next question is debt inheritable?
Some types of debt are, some are not. So you have what's called recourse debt, which is debt that the decedents and the beneficiaries of that decedent are responsible for paying. Some debt can be assumed so that you don't have to actually pay off the debt, but you in whole, but you actually take over the debt. And then there's other debt that's called non-recourse debt, which only the decedent would be responsible for. And if the decedent died, then there wouldn't be any security and it wouldn't pass on to the beneficiaries.
And so next question is, if you're paying off a car, should you put it in the trust?
So in general, I don't put cars in trusts. There's a very simple process through the DMV or AAA, if you remember, to transfer cars. Unless it's a collector car or really worth something, we usually say just put 2 people's name on the title, or even if it's just a single name, they're fairly easy to transfer. They can be put into trust, usually use a general assignment. Most people don't actually change the pink slip to be in the name of the trust.
And so next question is, are we able to put a mutual fund account in the trust's name?
Yes, you can. So your financial advisor could help you rename that mutual fund, the account that holds that mutual fund, so that it gets named as the owner, as the trust, and not the individual.
And so next question is, I had a trust when I was married, but have since gotten divorced. Does this make the trust null and void?
So there are, depending on what state you're in, there are some laws that will make portions of your estate plan null and void, but it doesn't make the entire document null and void. So some of it could be operational and some of it may not. The better thing to do is to redo your estate plan to make sure it's exactly what you want, because you may get some unintended consequences there.
And then so next question is, can you briefly explain any tax impacts of beneficiaries of bank or retirement accounts?
So bank accounts, go ahead, Keith.
Okay, well, I was just gonna, that's an it depends answer as well. Bank accounts, as far as taxation, qualified accounts, is it a Roth account? There's a lot of variance there, so that's generally speaking. Let's say you own a security at a bank, a stock you bought for $10, for example, it's worth $100 now. You die, whoever is entitled to that stock will receive what's called a stepped up cost basis. So essentially they could turn around and sell that stock and not pay anything in the form of capital gains or income taxes. So that's kind of an it depends answer, but I think Jeff, you probably have something to add to that.
No, I mean, you're right. It depends on the type of accounts. From an estate tax perspective, again, if the estate is over the exemption, there'll be taxes on those, regardless of the type of account. On retirement accounts, they get really complicated. If they're Roth accounts, right, there's no tax when the beneficiary is taking the money out. If they're traditional retirement accounts, 401ks, there would be tax because you don't get that stepped up in basis on the retirement accounts. Those are only on non-retirement accounts. If you name a trust, our new rules now are, within 10 years, you have to take out the assets, the required minimum distributions, which would be taxable. So it can get pretty complicated depending on the type of plan you have.
Great. So next question is regarding how mortgages are handled. And what if you pass away and you have a home with joint tenancy and there's still a mortgage? Does it roll over to the person who's still living?
Not necessarily. It depends on whose name is on the mortgage. So if both joint tenants are on the mortgage and on the house, then it may roll over to that one person. But oftentimes mortgages, it really just depends. If the mortgage is secured by both of the people, there could be a due on sale clause on there or a due on death clause that when one of them dies, it calls the loan and that you have to pay it off. So that's a question you really want to talk with your mortgage broker about and make sure you understand the type of mortgage that you have.
Great. Next question is, if you have a beneficiary for a living trust and a successor's trustee, do you still need to designate a beneficiary on IRA accounts?
Keith, you want to take that?
My stance on this is anytime you can list all those retirement accounts and 401ks and life insurance passed by operation of contract. So they supersede, again, we talked about this, anything stated in a will or a trust. So I'm in the camp that if you can list a physical actual person on a document like a beneficiary form, that would be my recommendation, to list a real person before going into the trust, and it just gets convoluted at that point.
Yeah, I agree. And you have to make sure you actually name someone. If I understand the question, I mean, just having a trust alone is not going to put a beneficiary on your retirement account. You actually have to fill out the beneficiary designation form for your retirement account to name the beneficiary.
Next question is, can you put ESOP shares into a trust?
Generally, yes. It depends on your ESOP arrangement. Usually you can.
And then next question is, what amount of wealth really starts to make sense to create a trust?
So I usually say if you have minor children, regardless of your wealth, you're going to want a trust in some estate planning documents. And if you're over your state's small estate affidavit exemption, again, California, $166,250, right? Because then you start getting into potential probates, and you would want a simple trust to handle that.
And so next question is, if I only have IRAs and 401ks, what do you think would be the best suggestion? I think that might tie to the question that you just answered a little bit too.
Yeah, I mean, if you literally have nothing else but IRAs and 401ks, then probably you'd be okay just naming your daughter as the beneficiary of those. Again, depends on the age of the daughter. We didn't talk about guardians. Part of your estate plan is who's going to take care of your minor children if you die while they're minors, right? If you don't have a document for that, then it's going to be a pretty big mess and a lot of court proceedings. So it's not just financial related when you're looking at an estate plan. And remember the other documents too, right? The advanced healthcare directives, the durable powers of attorneys, those aren't financial related. You're going to want those no matter what.
And so next question is, how often would you suggest updating our trust?
Well, so we usually say, if there's some major changes in your financial situation, major changes in your personal life of your beneficiaries, major changes in the tax law, right, is when you want to start making changes. So usually we say, every 3 to 5 years, you should at least check in with your estate planner. And just, most people won't charge you for that call of, a couple of minutes of, hey, what's going on? Do I need to make a change? We had a big change in the law several years ago regarding, it's called portability. So that, we talked about that estate tax exemption. And it used to be that when the first person spouse died, you either used your exemption or you lost it. And so estate plans were written around that. And you'll hear terms like an AB trust or an ABC trust. When the law changed, it now says when the first person dies, you can port or transfer the exemption of the first decedent to the surviving spouse. So if you have a trust that was created, assuming no portability, your trust is going to give you some very bad tax consequences, and income tax consequences, not related to estate tax, income tax consequences, that if you didn't call your planner and know that there was that change in the law, you wouldn't have the opportunity to change. So every few years, you should at least be checking in.
Great. Next question is, I think there was one slide we mentioned the advanced medical directive, but we didn't really discuss it too much throughout the content. How do you set one up, and can you set one up on behalf of a parent?
So at the very simplest level, if you want to do it yourself, you can, most states have statutory advanced healthcare directives. So you could do a search, for healthcare directive in California, Arizona, whatever it is. And the code will have, and sometimes the medical associations for those states will have a kind of a default form that you could use. Those forms are the very basic form out there, right? There are other things that you can add to those forms that the attorneys usually do when they draft, dealing with, maybe religious ceremonies, religious care, palliative care, pain management, preferences for being at home in a facility. Those types of things aren't in the default form. You could start there, or you could talk to your attorney, but you cannot create one for your parents. You have to create one for yourself. You have to have the capacity in order to create your own.
And so next question is, you're thinking about a will, living trust, can they all be done with your estate, planning attorney and a financial planner, or do you need, different or specific attorneys to help with these things?
So your estate planning attorney will do all the drafting. Your financial planner will help you, and the estate planning attorney maybe help design the plan potentially, or go through the assets, make sure the assets are properly titled in the name of the plan. But you don't need anybody outside of that.
And so next question is, if I have a living trust with my child as a sole trustee, and I remarry, would my assets still go to her upon my death, or would the husband be entitled to a portion?
No, the assets will follow the trust with whatever the trust says. So if you don't add the husband onto that trust, the husband would not be entitled to anything.
And then so next, I may have missed this, but can we briefly explain a little bit more detail about why you wouldn't put a 401k in the trust due to tax implications?
So beneficiary designations on retirement accounts is a very complicated area. You have to have what's called designated beneficiaries. A trust on its own is not a designated beneficiary unless the trust has some very specific language that allows it to be. If you don't have the language, then you have to take all of the assets out of that retirement account within 5 years. If you do have the language, for surviving spouses, you get to take it out over the surviving spouse's lifetime. For non-spouses, it's now a 10-year rule. That was the change. Every asset, the requirement of distributions in the entire trust would have to come, or entire retirement account would have to come out without 10 years. You can add some bells and whistles to your trust to keep the assets in there, but it could get taxed at the trust level. Taxes get trust at the highest income tax bracket, so you might wind up paying more tax than you would if it was just named as a beneficiary. I know that's a very high overview, but it gets very complicated depending on the set of beneficiaries and how you set it up. But it could have some very severe income tax consequences, because remember, the whole game with retirement accounts is deferment, 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 right? You want to defer that tax for as long as possible. And in a trust, you lose potentially some of that deferment.
This next question, I think Jeff will like after a brief conversation about LegalZoom. But if you were to use Susie Orman's tools for creating these official documents, your power of attorney, will, et cetera, is this sufficient, or are there some issues with this approach, assuming all documents are properly notarized?
I'm not familiar with her documents per se, so I can't say anything about her documents. But what I'd say about these kind of online tools and do-it-yourself type of tools is the documents themselves tend to be legally correct, but bare bones, right? And so if you have anything that's outside of kind of a bare bones plan, oftentimes there's some issues with the plan. The other part of it is especially like with these online LegalZoom type of scenarios where you're doing it yourself, if you don't understand the terms and the consequences of what you're doing, the form itself might be correct, but you might have filled it out wrong, named people with the wrong titles, right? And so you might not wind up having the plan you think you actually have. So I always suggest that you have an attorney at least review the plan.
And Jeff, just one quick question. I'm interested in your take on this. As far as a living will, 5 wishes, that online option, do you have any thoughts surrounding that if someone doesn't have a living will in place?
Yeah, I know that's kind of the hot thing right now, this 5 wishes. I mean, I think having something is better than having nothing, and the more time you spend thinking about it and having something in place, the better off you are.
Okay, thank you.
Next question, thinking about refinancing a house, we mentioned something about being careful with your trust and listing this asset. Can you elaborate?
Yeah, so if you have a trust, you want to make sure that your house is in the name of your trust. Oftentimes when the mortgage company refinances, they won't refinance to a trust. So they make you take the house out of the trust, put it back into your individual names, then issue the mortgage. And some trust companies will then put it back into the trust, but some of them don't. So you just need to make sure that you talk to your trust, your escrow officer, and make sure that if they do that, that they put the house back into the name of the trust so that you don't have a probate issue down the road.
So next question, I think this comes into like best practices, is if I updated my trust documents, should the old documents be destroyed to avoid confusing anybody, or do you like to keep those for historical records?
So the safe answer is you should not destroy them. One of the main reasons being is if your current documents get contested, so you die and a beneficiary comes up, contests them, says you didn't have capacity or didn't know, were unduly influenced, and they get thrown out, then your prior documents are the ones that will apply. If you don't have those prior documents, then you could be looking at a probate situation. So you should always keep your prior documents.
And so this next question, which I think it probably varies pretty widely, but what is the typical fee range for estate planning services?
Yeah, I mean, I don't even know how to answer that. It could be, I think LegalZoom, I think is charging like $500 the last time I looked it could cost $50,000 to do an estate plan or more, depending on what's being done. and the area that you're in. But it's most attorneys, I suspect, are charging several $1,000s to do it.
And so, it is the top of the hour. I do want to be respectful of time for anybody that needs to drop. I did not check with Jeff. I just said in chat. Do you have a hard stop at the top of the hour? We do have a number of questions and a lot of attendees still on.
I can stay as long as there's questions.
Got it. So for anybody that does need to drop, thank you again for attending. Please do fill out our post-webinar survey. This is officially the end of our webinar, but we will continue on since we have so many great questions left on for anybody that does want to continue listening to our questions. So our next question is, my oldest child is 31 years old, owns a condo just under her name and a house under her name as well as the couple. Does she need to be concerned with any of this at this age, will, trust, etc.? What do you recommend?
Yeah, she should absolutely have a trust if she owns those types of assets. Age is really irrelevant, right? I mean, you could die at any age. Accidents happen. So don't wait until you're 70 to do an estate plan.
Next question is, how can a trustee become educated on what his or her responsibilities are? If anything, that a trustee can do to reassign the responsibility if they themselves become incapacitated?
Yeah, that's a tough one. I know for us, we give a little packet to our trustees that kind of talks about fiduciary duties and what you need to do and to give some education on that, how to administer a trust. Not every attorney does that. And if not, I mean, it's really, again, talking to your attorney, talking to a financial planner, just, getting some ideas from them. There's probably some books out there, NOLO Press might have something. I don't know, I haven't looked, but they may have something on that. Maybe just some general Google searches might help you find something.
And so, as a married couple, can you change the terms of a revocable trust if the spouse does not agree to the change?
So this depends on what state you're in and what your document says. There was a big case a few years ago, Masry versus Masry, which was the Aaron Brockovich movie. The attorney, Ed Masry, got divorced and changed the document on his own, and it caused a huge change in the law. The general rule most plans say is you can change the trust as to your separate property and your half of the community property, but not to your spouse's. And then there's questions on whether you have to actually give notice to that spouse or not, which will depend upon the state law and the document.
So next question is, I've heard of naming your trust something that's not associated with your family name to protect your assets from potential lawsuits. Is this true?
So with your living trust, it's not going to make any difference. There's no asset protection in your living trust or your revocable trust. Putting a name on there might slow your creditor down, but you're still liable regardless of what your name is. With an irrevocable trust, oftentimes we use generic names, especially if you're doing charitable giving and you don't want your name associated with it. That's more for just privacy, but not so much avoidance of creditors.
And can you speak a bit more to the small estate and what's involved in releasing these assets?
So I think every state has this process. It may be a little bit different in each state, but in California, you have what's called the small estate affidavit. It's in the probate code. You can do a Google search for it. You'll find the form. You have to wait 40 days and you fill out this form that basically says, I'm the only heir. The estate was underneath the $166,000 dollar amount. And you provide that form to the bank along with the death certificate, and then they should transfer the assets over to you.
So next question is, how do you make a change, if even possible, to an irrevocable trust? For example, maybe changing the beneficiary to the home.
So my general answer is going to be you can't. That being said, sometimes there are ways, depending on using trust protectors and independent trustees, or what's called decanting, which is moving your trust to another jurisdiction. So there are some very sophisticated ways of changing your revocable trusts, but 99% of the time you can't.
And so the next question is, if you have your child as a primary beneficiaries, can you also list them as a secondary contingent beneficiaries?
Keith, you want to take that?
The primary goal or objective to having a contingent beneficiary is if the primary beneficiary predeceases. So I would probably look at listing someone else as a contingent beneficiary.
So next question is, can you avoid taxes on a 401k and IRA account funded in a state that taxes distributions be avoided by moving to a state that does not tax retirement account distributions?
So you're always going to have the federal tax.
Right.
State income tax, you might be able to avoid. You got to be careful because some states have what's called throwback taxes. So if you're in one state and you move to another state and then you do a transaction, you still have to pay the first state taxes. So you got to be very careful on trying to do that type of planning, but there are ways of doing it.
And so the next one, maybe good for Keith is, is college debt passed on to children?
Is college debt passed on to children? No. And essentially, maybe Jeff, actually, you could chime in. Would that be one of those debts that you were referring to earlier?
My understanding is it depends on the type of college debt. I believe that federal college loans are forgiven at death, but private loans are not. So depending upon who your lender is for that college debt, it may pass on. And I shouldn't say it doesn't pass on, it becomes due and payable, right? It's not like that your child continues to make the payments on it. It all becomes due and payable upon death.
And so the next one, which I think is very timely, especially with hard assets and jewelry and art starting to be purchased more frequently, is jewelry, especially if it's more expensive, is that something that you would suggest putting into your trust?
So we normally do what's called a general assignment that assigns all of your tangible personal property, so your watches, your jewelry, your furniture, all of those types of things into your trust so that your trust can handle it. Some attorneys use your will to do it, but I think most people do put it into the trust by a general assignment. If it's a piece of particular value, you might even do a specific assignment for that piece. And if you want to make sure you give it to a particular person, then for sure you want to put it in your trust. And then in your trust, you say, my diamond ring goes to my daughter, or whatever it is.
And so, what are some examples, of debt that survivors would be responsible for? Like we just mentioned, potentially, private student debt. What are other things that they would be?
I think the general rule is you should assume that the survivor will be responsible. And again, being careful on language, right? So if I die with debt, my estate is responsible for paying that debt. So if I have enough assets in my estate and it's a recourse debt, which is the way most debt is, my estate is going to have to pay it. So my trustee or my executor is going to have to use my assets to pay the debt. It's not so much that it passes on to my survivor and then my survivor is making payments on it. The survivor might wind up doing that because they might have to go to the creditor and say, look, there's not enough money in this estate. We'll work out some type of a plan, but it doesn't automatically go to the survivor to be responsible for it.
Okay, so now the next question, which I'm going to skip a couple because I'm going to ask two together at the same time because they're along the same lines, is one, can you explain cost basis and what gets stepped up and what doesn't get stepped up between a trust and retirement account? And then the next piece of that is if you have a brokerage account in the trust and one person passes away, does the cost basis for everything step up or only a portion of it?
So in general, you can think of cost basis as what you paid for an asset. So if I paid $10 for my stock or $100,000 for the house, that would be my cost basis. When you sell an asset, you take the fair market value of what you sell it for, you subtract the basis, and the difference is what you paid income tax on. So at death, all non-retirement accounts will get a step up or a step down if the value went down, in basis. So that if you sell the asset at the moment or quickly after death, the fair market value and the basis are the same, so there's no tax. Your retirement account, though, does not get that basis step up because remember that you're deferring the tax. You didn't pay tax when it went in, right, on a traditional IRA or 401k, which is why you don't get the basis step up in that account.
And so next question is, what happens if you die after creating a trust, but before assets were formally renamed and transferred to the trust?
Yeah, so that can be a problem. Usually with your trust, you do a Schedule A or an assignment where you list the assets. And every state's a little bit different on here. In California, we tend to list the assets that you intend to put into the trust. And then you can go to court and do an abbreviated probate, what's called a Hegstad petition in California. Different states have different proceedings, but they're all similar. Where you basically go to court and say, look, court, I don't want to do a probate. I have a trust, but I didn't fully fund it. But look, here's my list of documents or my list of assets that I intended to be in the trust. So just give me an order saying that these are actually trust assets. So it's a very abbreviated process that usually only takes a couple of months to get through.
So next question is, we mentioned something about designating non-family members. So for somebody that's unmarried, but still with their partner and they have children together, is there anything significant that they should think about in financial planning, being that they're not officially married?
I think there are probably more, legal aspects to that, as there are always financial decisions. I mean, if you're filing single versus jointly, is there a benefit to being married? Social Security benefits, I guess that's another, it depends answer, so to speak. I won't speak to the legal side of that. I think that's probably more in Jeff's wheelhouse here.
Yeah, I think on the legal side, one of the main things is the marital deduction. So you can leave assets to a spouse without any tax consequence, but that's not true if it's a partner and you're not married or a registered domestic partner. There's also issues, of if there's a divorce or a separation, and what's alimony or palimony, as they call it, for a non-married person, what they're entitled to. There could be questions about, did the partner put some money into, say, fixing up the house? So is part of it owned by that partner? So you need to kind of work through those issues. There could be some issues there.
Great. So next question is, what is the best way to prove intent for a trust where kids are estranged?
So proving intent is always a difficult thing. Oftentimes we'll put intent language in the trust document itself. The settler intends such and such. Sometimes we do it by a separate letter that could be attached to the document, but it's not part of the actual document. Other times it's just maybe the attorney's notes that are in there, or we ask the client to send a letter to the attorney. Kind of depends on the situation. Some people talk about videotaping the decedents, or while they're alive, of what their intent is. Most litigation attorneys will advise against that because it just causes a whole bunch of potential issues of if it's not something that you do regularly. So why did you do it for this person? And you might say something that could be used against you. So you want to be careful with that.
And so next question is, what if I have a living trust for my estate to my son and I become disabled with large insurance bills? Is the insurance carrier able to track down my estate to pay for bills?
Yes. Is a short answer, right? You're responsible for your debts, even if incapacitated.
And so next one, do you happen to know what the cost for the small estate affidavit is in California and how much documentation would be needed?
So there's no cost. I mean, you can download them off the internet and just fill them out and hand them to the bank. Basically, you need just the death certificate. And occasionally a bank will ask you for, kind of proof that you are the beneficiary. That's it. I mean, they're very simple to use.
And so, this one, I think we mentioned in California, the total amount that would make sense, but do you happen to know for somebody in New Jersey, what amount it would make sense to create a living trust?
I have no idea what New Jersey's law is. I'm sorry.
Yeah, so for that person, if you reach out to us, reach out to Keith, financialplanning@bfsg.com, we're happy to touch base with you offline. We do have contacts across the country and we could find that answer for you. Next question is, did you say that your trust gets taxed at the highest income tax bracket?
I did, but that was in the context of a retirement account in an irrevocable trust. So not the living trust that we're talking about here. But if you have an irrevocable trust after somebody dies that owns a insurance or owns a retirement account, you're going to get taxed at the highest bracket.
So next question is, thinking through the new law regarding, inherited IRAs and the requirement they are liquidated within 10 years. Do you know when it's went into effect? So if somebody passed away in 2019, but the IRAs were transferred in 2020, are those under the new rule or the old rule?
You want to say something, Keith?
Unless you have knowledge of this, I didn't want to give an incorrect answer. That's something that I can research unless you're familiar, Jeff.
I know the rule came in January 1st, 2020. My understanding is that it follows the date of death, not the date of when it actually transferred. So I believe your 2019, you'd still be under the old rule. But you should double check that. I'm not 100% sure, but I'm pretty sure that that's what the rule is.
So next question, if you are married and have a living trust, but your spouse doesn't have a trust or will all of their assets automatically go to the living spouse?
That depends on what, I'm assuming this person is not in California. It depends if you're a community property state or a separate property state and whose assets those are. If they're community property assets, then it would go to the surviving spouse. If they're separate property assets, then you would wind up going through probate, and probate splits the assets between the surviving spouse and the children. If you're a community property state and it's community property, I would suggest having a joint trust. If these are separate property assets, then you could use a joint trust, but you might also still want separate property trusts, so there's no issues there.
And so the next question is, speaking to the differences between revocable and irrevocable, if an irrevocable trust is so difficult to work with and nearly impossible to change, why would anybody use it? Or when is a really good time to use it?
So irrevocable trusts we use mainly for tax planning or asset protection planning. So for example, if let's say I've got a $15 million estate and I've got my $11 million of exemption, and I want to start reducing my estate tax. So I might use some of my exemption, put an asset into an irrevocable trust, and then the growth on that asset in the irrevocable trust is not included in my estate. So I'm going to save estate tax on all the growth, after death. Irrevocable trusts naturally get formed upon the first death. When your revocable trust, when the person who created it dies, if you leave assets in trust for your children, those trusts for the children will be irrevocable trusts. So they kind of come into existence then. But it's mainly income tax planning, estate tax planning, charitable planning is when we use irrevocable trusts.
So next question is, if I have my spouse as the primary beneficiary, would it be better to put my child as the contingent beneficiary or list the trust?
I guess that would kind of depend on the age of the child. Number one, when you list a minor, they can't take receipt of the actual account. It would be their guardian. So if you don't have that part set up, there could be some issues there as well.
Yeah, I agree. It just depends on the facts and circumstances.
And so this is going back to our questions about passing on debt. If I am an only child and my parents have $50,000 or more in defaulted debt, can I be held liable for it?
Like again, most likely you would not be liable for it, but your parents' estate would be. So if your parents died and they don't have the money, you would have to prove to the creditor that there's no money there. So usually it doesn't pass on to the beneficiary.
So next question is, can a beneficiary or trustee be non-American citizens? And then how does that work, especially with like Social Security numbers?
So a beneficiary can be a non-U.S. citizen. Sometimes there's some withholdings of tax when distributions are made to that person to ensure that the U.S. government gets their income tax or estate tax. The trustees is a little bit more complicated. I mean, generally the answer is no, unless you use like a corporate trustee who has an out of the country presence because they're registered in the US. But generally you can't have non-American citizen trustees.
And so next question is, if I am married and have a living trust, but my spouse does not have a will or trust, will all of his assets automatically transfer to me?
I think that's similar to the question we kind of just answered on that as well. That it all depends on if it's community property, not community property, you know, separate property, and what the probate rules are in your state, and whether you have kids.
And so we had a question earlier about having an ESOP, and can it be can you put it in the trust? So if you have the trust set up and ESOP transferred, can it be transferred directly to the trust to avoid paying taxes, or does it have to be paid out to me first and the assets placed into trust?
All right, so that, again, that depends on your ESOP document. So you have to see what it says about transferability and who can own it and who can be assigned to.
Great. And so with that, that was our last question for today. So again, I want to kind of thank everybody for attending the webinar today. Please fill out our post-webinar survey. Big thank you to Keith and Jeff, especially for extending time to continue answering questions for an extra 20 minutes after already a full hour of kind of talking today. Again, thank you everybody for attending. Keith, any closing remarks?
No, I appreciate the time. Thank you so much, and look forward to next week if you can join that webinar on the 7 pillars of financial planning.
Well, thank you all. Have a great day.
Thank you.
Thank you. Bye-bye.